should say I saw it.
We're like,
He had disconnected the internet.
send it to me on my own.
So we'll do that.
Welcome, everybody. We are live. We're sorry we're a minute or two late. We had some technical challenges, but we're here. This is the Senate Sexual Harassment Prevention Panel. I'm Allison Clarkson, and here's our fabulous committee. And I have news to report, which is Senate rules voted yes to accept the updated Senate policy, the uniform policy with the House on sexual harassment prevention. And it is now posted on our website, the policy work, which is great because this is really the culmination of what Damien and John, 2.5 years of work. So it's just terrific. Is that right? About right? Longer?
Somewhere in there.
A long time.
I've lost track at this point.
And what was nice is we kept the continuity of the work going between bienniums, which is unusual, and we passed it and it's been approved and it's up on the website. So the second piece of our work is to review the procedures as they stand now and to discuss any updates, the procedure which is specific to the Senate. Our procedures are different from the House, and I think for that discussion we have all had them, and I hope we've had a chance to review them. And I think who would like to lead on this discussion? John, would you like to? Should we walk through them and look at what we want to update or not?
I will sort of an overview and walk through. A full walkthrough will be almost like we just reading the different sentences, which is I can do also. But generally speaking, the Senate current procedures sort of look at trying to have anyone who is alleged victim or subject to some kind of sexual harassment drive the procedures. There are some places where other people can bring it to the attention, but that's sort of the overall goal, along with having some confidentiality. So I'll try to walk you through this. The first two are not the formal process or the formal hearing process.
Nope, I got it. I'm gonna make it work. I'm gonna make it work. Just ignore me over here.
We only have 45 minutes.
So
People better be. Okay.
there are really, if someone is potentially subject to some sort of a harassment, there are really three different ways one could address it. The first two are not required, but they're optional and they're out there. And that means that if somebody is harassed, they don't have to even look at these two. They can go straight to the panel, straight to a formal written complaint. But our processes and procedures permit there to be sort of some informal and some lesser steps in a full hearing. And so the first one, if you look on page 11, I think everyone has it, is identifying the objectionable conduct to the regulated individual. That is really that everyone has an ability to discuss it with the person who's a regulated individual, and potentially, this doesn't really say it, but you could have it done as a group setting or whatever it happens to be. That is a way of trying to say, let's address it if it's appropriate for something to be addressed like that. The second one is informally contacting a member of the panel. There is a distinction. I'm not going to discuss the distinction too much between what the House now does and what the Senate does, but this really allows someone to come and discuss with one of you, what are my options, what can I do, where can I go, what's out there. And if you are told, I don't want to go anywhere else, it's sort of, that's the end of it. So you as the potential alleged victim can decide that I've got my options, I see what's there, and I am not interested in going further. So, you can also go and ask that there be an informal sort of resolution, which means that you as a panel can ask if they want to informally resolve it. That's sort of like almost a mediation. And that's the process that's talked down through number 2 at 2A2. If you're given permission, you can attempt to resolve it informally. You can go talk to you have a complaint, then you have a respondent. You can even try to go and work out some sort of informal resolution without the full panel sort of being involved. If at the end of that they want to do nothing further is done.
Okay.
Then if if there is an informal resolution, there is some notifications so that it's not just within the panel. There's no names, no identification stuff, but the leadership is told, the House is the speaker and then the Senate is the pro tem. There are no really files that are necessarily kept. There would, of course, there would be a file that something happened.
Yeah, but I think that was maybe our question. What's your question?
Yeah, I was gonna be
That's
like, how do we, in the instance that this is a repetitive behavior, what is and even if the person doesn't want to move forward with it, that feels like good information to have, it starts to happen over and over.
We would,
Answer questions about expungement.
Yeah.
so we can make it clearer. It would probably be, I would tell you that if we actually received a complaint, something was done, we would probably have a piece of paper
Okay.
in my office, but it would not have any of the particulars necessarily. So the real issue is what is going to be contained in that file, and at some point you may want to give more direction either in this process or to us. The idea would be later on, as you'll see, there is panel is supposed to request past instances from various organizations and whether something has happened.
Okay.
So that's to actually fulfill that. I think there has to be something, but this may be slightly. It probably should be clarified that there is something or a notification. The other thing is, in my favorite discussion, if there's a potential complainant who wants their name not associated with it, it may be that it's sort of anonymous, but with the regulated individual's name on it. But it requires some kind of discussion because the more you identify it with the complainant, the more it may linger more than they want. And so at some point, you're going to be balancing, how do you weigh that?
So I think just a tag on to Becca's question, which is, at what point is a file created on an individual?
With our office,
And that is, I think what we're, so that there is something in case something occurs later, there's something to refer back to, so that.
there are,
Exactly. That other legislators know.
Or even the same person perhaps could refer back to.
Yeah. It is, would depend on what our office was told.
Okay, so is that a procedural piece that we may want to address in this? Is
Yes.
at what point is a file created?
If there's an ambiguity, we should probably have some certainty so that there's no question.
Likewise, is there language about when a file is destroyed? Because some of this, careers come and go and
So
not necessarily something that needs to be.
we have an informal policy in our office. It's not formally in here. It is really kind of a matter of how long have you been out? So if you decided not to run, my current policy is if you're still of the age of 40, we're probably going to keep it until you're like 60, just in case you ever came back. If you're 70 and you retire, we're probably keeping it for 5 to 10 years. Just, I mean, the whole idea is, and I also, the reason we've done that sort of as an informal policy is I'm not sure whether or not 65 years from now, when someone decides to go through my file and everybody's no longer with us, that it should be sort of, so there is some debate. I believe, I'm not sure what the House currently does, but I do know that there has been ambiguity in the past about disciplinary files for legislators, not only sexual harassment, but for ethics or other kind of complaints and how long they're kept. And I don't believe there's any sort of time on the Senate side. I don't know if the House does.
So that's another.
I don't mean to put you on the spot, David, but I don't think it's good one.
So,
So the House doesn't have a timeline for destruction, but they do create a brief record of everything that is filed with the panel, which, they're still working on, well, internally, we're working on improving how those records are kept and standardizing them. But there is no destruction timeline on the House side because it has a look back for any time you've served under the policy. So it's that same issue that John was mentioning, where you might serve when you're younger and then take time off, and then later on, when you retire, you might decide to return to the legislature for a second round of service. And perhaps there's history to something that happens in the second round of service that relates back to the first round of service. So
So I would tag onto this. I think this bears further discussion. I'd love to at least just get through the policy as it is now, but we need to put a pin on this because one of the questions we would also want to ask is, are our files able to be reviewed in case there's a bigger issue that happens outside this building and there's a legal case brought against the file filler, the person people complained about. Is it accessible? Is that able to be gotten by the state's attorney or by the
Not without a
AG?
Supreme Court opinion from our office. I don't know.
Yeah.
I mean, so generally there's two separate, that is not, it's confidential by the way you've done it, is exempted from the open record request. It would take, from our perspective, I'm not releasing anything in there unless it's a court order, and we probably have the AG go to the Supreme Court if we had an executive versus the legislative. Unless the panel or something was changed, I would not, it's just me, as your secretary, I would not be releasing it without a Supreme Court opinion.
Okay,
Yeah, but I don't know what.
but that's just a logical extension of what are we keeping it for? And if it, so anyway, okay, so let's put a pin on these two questions and come back to them unless we have something else.
I just have
Yeah,
one more
Andy.
question. These procedures, are they gonna be the same in the House or are we adopting them?
The House has different procedures from the Senate because of some of the differences in how your panels are run and constituted.
Because in here, we
So-
say what the chair of the House panel is gonna do.
So now I'll give you some background. So one time before the House changed their policy, we both had this exact same word for word going back
Yeah.
3 years ago. It was adopted. The House then, when they came back about a year later, they adopted a different policy and or procedures. But I think it's sort of evolved over the last couple of years.
Yeah,
And so we at one time had the same. At this point, your policy mirrors theirs. It's kind of,
Yeah.
but this, we did not touch. And so when we put this together for y'all to review, I at this point
So
adopted.
that's something that we might update.
Yes, but that's why it's in there now.
yeah, so this is just, all that House-related language can come out
Sure, okay.
at some point.
The other thing I should mention for file center is generally, there's timeframes as to what type of action you can have a complaint about.
Say that one more time?
The
There-
statute of limitations.
Well, sort of. So it has to be about this term. So if all of a sudden somebody comes back, is elected, they can't say, 4 years ago, blah, blah, blah. And so the reason I mention that is it's from Senator Weeks's question about how long we keep them, is that your file, if you have one, is really on the penalty phase, not whether or not you're guilty this time. If you want to think about it kind of criminally, it's sort of like, have you had complaints before? How do they relate? It's not really whether or not, at least from our perspective, whether or not something was done this time. It is there a pattern we have to think about? But the complaint itself has to be sort of about this time sitting, because that's how you regulate them. Your senators have an ability to regulate their own senators. It's harder to regulate outside.
Got it. Okay, let's keep moving.
So then, if you get to the other people make
Right,
one more thing on the file. Right now, this contemplates that my office is not necessarily told if a single panel member mediates or coupled to, just so you'll know, because there is no record the way this is kind of done. If we were told, we would keep one. And so as you work through that, you're going to want to kind of figure out, do we have to be told or just file? The next one is a third party can come up and talk to a panel member. The House and the Senate are different. What kind of occurs here? This is still voluntary by the potential complaint, let's put it that way, or the alleged victim. So third party sees something that they're not really sure that is appropriate. They can go to a panel member, and that panel member can sort of investigate, or at least go talk to the potential complainant. Find out, was there something done? Was there something not done? That you have your abilities to do things. And so that's a third party's sort of reporting it. The third party, in the way the Senate does not drive it. The third party cannot go to somebody in the panel and say, you must do this X, Y, Z against your potential complainant your victim may desire or not desire. I think after we finish ours, I think Damien's supposed to kind of walk through the differences, but I think it's different. I think that once there's a complaint, there has to be something sort of done depending on what there is. So that's the second.
well, yeah, I would put a pin on this. For who they discuss it with before they do anything rogue on their own. So I think that needs further discussion.
So that's sort of the informal process. Then there is a more formal process. and you actually can file a complaint. This has to be in writing, it's supposed to be signed, it can be given to any panel members, chair gets it, there's kind of a process for how it kind of works through.
Well, there are two processes, right? One is it could come directly, and one is it could come through the ethics commission.
So generally speaking, the ethics commission does not come directly to the sexual harassment panel. The ethics is an ethics complaint. So this was there, it depends sort of on their vision. This was before there was an ethics commission. But the ethics commission deals with ethics, not sexual harassment directly, complaints.
Right.
And so when they refer them, they refer them at least initially to the ethics panel. And then if it had something to do with sexual harassment, it would probably be referred here, because if you look at our Senate rules on ethics, they're not supposed to do anything with sexual harassment complaints.
Right.
And it's actually excluded.
Right.
So, yeah, no, thanks.
Seems to me that there could be a Venn diagram of the kinds of complaints that might be potentially falling into both categories, but if it's specifically excluded, I mean, doesn't that mean that there could be a pathway where it starts with ethics and then ends up here?
Yeah, generally
Well, that's
speaking,
good.
it would be, the ethics commission is not really there.
It's to defer. It's to refer.
Ethics complaints. And so whether or not a sexual harassment complaint would go through, whether it would come directly,
Okay.
I don't really know.
Okay.
But it can, and they have certain statutory things they're supposed to look at to make it an ethics complaint. It's got to satisfy the standards, the statutes.
So in that way, it could come from any, it might come from the ethics panel, but it could come from really anywhere. And the point is, it's being funneled.
Correct.
If it's under our jurisdiction, then it would
It'll
be
get
funneled
funneled
to us, regardless of who it comes from.
Generally, if you get something through the ethics commission, it is going to be a formal complaint, because the ethics are required to be signed and in writing. The first informal process is, if you get something referred all the way through, it is not going to be through the informal process. It means someone has actually signed, written up what their complaint is. Okay. Now you then have the formal panel process. As I said, there's a filing a complaint. There's no real form. We don't have a form that's printed out. You have to fill out, but it has to be in writing. And the procedures are, once it's been received by the chair or by another member and moved through, then the panel is supposed to provide the regulated individual, who's the person that's being complained about, a copy of it. They have a right to file a response. And if there is a copy, the panel is supposed to give to the complainant, whoever filed the complaint. At that point, it's reviewed. The panel can make a decision whether they don't want to do anything. Oh, I'm sorry. If there are criminal pending charges pending, you can put the panel's investigation on hold or in abeyance. This actually has some history from the Senate. As we worked through this last time, there was potentially some criminal charges pending, and there was a question whether or not, if they went forward, whether it would prejudice either the criminal or vice versa, and how could someone defend themselves. So this does not say you have to put it on abeyance, but it says you're given the opportunity to consider that and decide whether or not it's best overall to put in abeyance the investigation that you're doing here in the Senate, if there are criminal charges. Got it. The paragraph 3 is a interest kind of thing. You can't, if you're the member, if you're the complainant or respondent, you can't serve on the panel for that particular one. You can't discuss it. It's sort of to keep out there from being people who have particular interest in that particular complaint. Number 4, you can make a decision that there is not a sufficient allegation to move forward, that there's not a violation. That would be reviewing the written complaint and the response. And it may seem that is potentially impossible, but this gives you leeway that different things happen. Sometimes, I think the House is a little more strict about what they have to do, but the idea here is if there's a circumstance where after reviewing the 2 of them, there is no violation, then you actually have the ability to dismiss it. As an extreme example, one could overhear something that they just misheard. There's a written complaint done, and then after after it's actually responded to, you know, if everybody says, "Oh my goodness, well that was a mistake. I'm really stupid. I shouldn't say that out in public. I will never do it again." Should you have to go through a full process, this kind of gives you the opportunity to dismiss something that maybe shouldn't proceed. There may have been a misunderstanding. Is a real trivial example, but it could happen. You have an ability to contract with an attorney to do an investigation if you decide to move forward. I think the House is a little more strict unless they've changed it. I think that they have to hire somebody. That allows you to decide, do I want a full investigation? I mean, you can decide to skip some of these steps, as we'll see. You could just, you know, if it's horrific, you could bring immediately a resolution to the joint Senate rules and ask to have the person kicked off the floor.
Wow.
And so
Sort of like what's just happened in Tennessee.
well, I'd like,
Or
This has more procedure in it than what happened in Tennessee.
Yes, but
we
we are
would-
not Tennessee, and that is a good thing.
we have followed a procedure. We've had problems before. My advice at that time was a little different than what they do elsewhere.
Right.
So it would be the same under any kind of a similar circumstances. Doesn't mean the outcome would be the same or different. That would be for you all to vote. But
We treasure our differences.
from our perspective, there would have been potentially a slightly different recommendation as how to proceed. But you can move directly to the floor with your policy. I'm not sure what the House would do if they have to do it. I think their wording is you have to. I suppose if they didn't, it would be okay. So you have a right to hire an investigator. If there's a lot of he said, she said, and you want at least a report, there's still later on a formal hearing. This is sort of investigative stage. But the idea when this was drafted, at least from the Senate's perspective, was that it gives you some flexibility where you may need it. And frequently you may not need it, but it's there. It's a lot of different needs.
Becca, you've done.
Thank you, Chair. So the one area that gives me a slight pause for concern is that a lot of this funnels through the speaker or the pro tem. And I could see situations in which either the speaker or the pro tem could be in fact the person either in complaint or complainee situation. And my understanding with the third party piece is that might be the angle in which you could. So I guess I'm looking at the investigation as a way to work if that is the situation. So is that a place that we could look at that? Or do you see any risk in the fact that that all goes through potentially two offices that may in fact be participants in some way in a situation?
So this, pro tem's office controls the process a lot less than maybe the speaker.
Okay.
So on this side, if there's an informal, there is a notification to the pro tem. Pro tem is not notified when there is a potential complaint. The only thing that happens at the informal is that the pro tem is notified. That was a compromise that was put in before because the speaker and pro tem didn't want to suddenly get called by the press and say what's going on. Honestly, and that was really
Yeah,
to ensure that there was some notification, no names, nothing, but they hear. It is not much more at that phase, I don't believe, than what you have to report at the end of the year. So at the end of the year, you have a yearly report, and if there was an informal one that was given to the pro tem, then they might know it's still going to be in your report. And we had 3 informal ones, blah, 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 they were resolved. And so I think the information, at least from what I'll be providing to a pro tem, would be similar to what's in there for the informal.
And in the instance that.
A formal one
Yeah.
depends a lot on what happens. So if the complaint's dismissed, I think what happens is they're notified. I have to mark down through because there's a lot of stuff in here. But I think what happens, if there was one that was dismissed, you guys here just decide to dismiss it. I think the pro tem gets notified, there was a complaint, it was dismissed. I don't even think at that point they're told who it is.
Right. It's not until a little further they're told who it is.
Yeah, when there's a recommendation for punishment, and at some point, there is more notification, punishments. So one of the things we've done in the past, we didn't go through this whole process in the past. People were removed from their committee in the Senate. In the House, the speaker removes people or assigns people to the committee. On our side, it's the committee on committees. And so when we had an instance before, that particular senator was removed from their committees within about a week because they decided that was the first year in May. the more formal process of removing their ability to vote on the floor was done the following January, after a little bit more of a debate on the floor. But the speaker has a right to change committees any day, any time. And then on our side, the committee on committees.
Got a little more.
Yeah.
So I guess the reason I'm asking that question is in the instance that the outcome of an investigation by the third party, like if it is a situation in which it is the person who is getting notified, the pro temp or speaker, for example, is there, like, that's when we get into a legal case.
So
It would, so I
understand
just,
the
where are we opening ourselves up to liability if we're sharing information with potentially,
at this point, at least in the Senate side, I don't know what the house. If there's an investigator that you all decide to hire, pro tem is not formally notified the way this goes.
okay,
Neither is the speaker. Now,
Oh,
that's,
okay, so
at this
that's-
point, until we get farther down,
has been closed.
Yes,
Is
right.
when it's closed. So then they're not given like, because I'm just worried if there was given like advance notice and then someone said that made my workplace
Yeah.
unsafe and I couldn't move forward through like a,
Yeah, no, the notice is simply a complaint has been filed. So it's, we had an informal complaint and then short time later, the complaint's been resolved.
okay, that makes me feel
Same
better.
thing with the formal complaint until you get to a point where there's a recommendation. And I think this is the same for the House and Senate. It's only when you get to a recommendation of corrective action of some sort
And that's the punishment.
that there is more than just a statement of the formal complaint I notified you of on such and such a date has been closed.
Okay, yeah, because it says a brief letter summarizing the panel's actions for when it's
I'm
closed.
sorry.
Sorry, I
Page
meant,
13.
yeah, page 13, that's the,
Which number?
oh,
Number
two.
seven.
Well,
7.
Okay, I wasn't quite that far. Yes, but yes, yeah, that would be.
Seven I two.
So should we just get to that first?
Okay.
Can I,
Yeah.
There's what's written on the paper and the process and procedure. And then I just want to make sure I'm clear, there is money involved. And so I just want, investigator is not free. So generally speaking, you ask there is money, I believe, set aside in the budget for the panels to be able to do this. There's a consultant. But remember, if it's a major one, it doesn't mean that there aren't other things that have to be done depending on the extent of the investigation. If you had some really major one, somebody's gonna have to approve the expenditures above and beyond what the budget is. And generally speaking,
We haven't.
we haven't needed to.
That is a good, that's a logical reason for them to, okay, I
So
understand.
if the Senate had decided to do a full investigation on the one senator we did a few years ago, it was not taken as a sexual harassment complaint, it went through the rules committee. But if there had been a full it might have been a little pricey, just to work through it all. And so in that sense, I just want to make sure that if whoever has one where, as the senators know, there needs to be certain approvals for certain expenditures at some level.
Yeah, I mean, we would, if you went excluding the work that the legislature's outside counsel already does for human resources, and that's who the House panels use. And you would blow through the retainer there with 2 weeks of full-time work on a case. So, I mean, you hope that it's not that much time for an investigation, but if it's a really involved, complicated case, you could easily go through that. So at that point, I mean, that's why you have this notice. We've moved it to an investigation. We're not telling you who, but we might be coming to you with a request for additional funding.
That is very helpful information
Yeah.
for why we have it in the way that we have it.
So
Thank
the-
Yeah,
So that was 5, you can contract. The 6, the chair of the panel is going to write a request of ledge counsel, Senate secretary, office of the general, and other offices. The reason that's in there is back to, are there reports elsewhere? And that was what we had the discussion earlier. There are other files, and those files could be various different places depending on who it is. All those groups are listed because at one time this was a more joint policy, and so that's why some of it's it may need to be tightened up for just the Senate. then the outcome of the investigation, at that point, if there was a report, that's why it says if any, you'd sit down and review it, and you make a determination if there's reasonable grounds to believe the respondent committed a violation of the policy. The Senate policy, I'm going to talk a little bit about criminal law for a second, so bear with me. When this was put together, we had we had an attorney and a few other people that were on the panel that were senators, and so the reasonable grounds is sort of like, should there be charges filed if you had a criminal charge? The judge does that, it's probable cause. When a police officer does an investigation, they submit it to a state's attorney. The state's attorney says, yes, I'd like to do charges. They submit it to the court. You're given a citation, and the judge signs off saying there's probable cause, meaning if we believe everything that sort of is said by the police and in their stuff, not necessarily with the other side, there's at least reasonable belief that if it's true, there could be a problem. So that's the first sort of standard here. I'm not sure what the House has done. They may have changed some of that, but that's what you all are looking at is, I got the information, we're going to take it as if it's sort of true, and if you believe at least one side, rather than weighing it, you're not weighing the two sides, that there's at least sufficient to be there, then you would go to the next step. And if it's not there, then you would dismiss it. There's no reasonable grounds. That's the one, and the chair shall meet with the complainant and explain it. There's going to be a brief summaries of what the action and why, and the chair will let the speaker or the pro tem know. So that's all kind of the little if you decide there is reasonable grounds that a policy, then you're going to meet with the two of them either together or separately. And you still, at this point, have some flexibility. There's still an ability for them to kind of work it out if they want. There is no requirement. There is no forcing of either party to be meeting with anybody. There are times when it may be useful, and there are times when a potential complaint wants nothing to do with any, say nothing about the same room, but the same building with people. So in that sense, this is built in some flexibility. They also have they can meet together, they can review the report by the attorney. Sometimes if you've gotten to the stage, it's sort of, I'm gonna use a phrase that may be appropriate for today, but I hope it doesn't step on anybody's toes. It's kind of like a come to Jesus moment, right, where somebody's given a little thing about an investigation and they're like, oh, this is not really the way I see it, or what have you. And so in that sense, this is sort of that possibility. Sometimes people are like, this, you know, it's better for me to try to resolve it and see what happens. So that's all in here. You can sort of just kind of work through it. And then you can do any of the following. You can do a warning. Once again, it depends on the extent and what's there. Now realize at this point there still has not been a big focus.
Yeah.
You know, and so it's this has been written from when it was done before to give you all flexibility. It doesn't mean you can't move to a hearing quicker. It's just that these are sort of steps on gradients to see if it's possible to resolve it, along with allowing the potential complainant to have some input as to how far they want to go and what they want to do. So you can issue a warning. That would be in a permanent file, at least as long as it's retained.
Yes.
You can meet mutually agreed upon resolution. If the two parties agree on what's going to happen, that will be retained too, because we've got a formal process working. You can, or you can decide that you're going to have to present charges, which is that little Roman numeral 3 there on page 14. And so in that sense, that's going to trigger the panel hearing process. And that's by doing the charges, and it explains sort of how it's done and who gets it, and whether you include the investigative report stuff.
Do we have a definition of charges?
That is, I guess there's not a definition, but that is really, here is what we are saying you did. It's like a criminal charge. It would be like you walked into your neighbor's yard, you trespassed, you know.
It's a description of the violation.
From my first, we haven't had to do a lot.
Yeah.
But from my perspective, if you were asking us, our office to draft one up, it would be a little bit like a criminal information, which says you have done X, Y, and Z, which we find is, and we may have more than one. You know, if there are 5 instances, you do it each one of them. That is going to be the basis for whether or not, you know, you got to prove these little things. Mm-hmm. And so in that sense, it's a little more than just saying we're going to start something. It is, it would, if it continued to work its way up, it would probably be the basis for the formal charges if there was like an expulsion in the Senate. You're kind of working it up through. You guys do a hearing, then you sort of make a recommendation. Usually it's to sort of the rules committee. The Senate itself is the people that punish you all, not a panel. You have to be only punished by your other senators, by the Constitution. There is the exemption or the exception for things like committees, because as it works its way up, there's at least 2 members of the committee on committees that are on our rules committee, and so as it kind of works up, there can be adjustments to committees. It becomes, I think the House actually does a couple of, I'm not sure how your recommendation deals with leadership, it deals with, other stuff, because I don't think you have an ability to enforce that, because that's a private party thing, Democrats and
The
Republicans.
charges aren't the punishments, it's like, this is how you violated our policy.
Yep.
These,
Describe
It's not criminal, it's not, like, these are
We're
not
not making
criminal
that.
justice charges.
well, they could conceivably,
It could
have
invoke-
a situation, you were here when we expel or suspended Senator.
From Frank.
but we're not making that determination of whether they are legal charges. We're just saying, here's the charge, we're
Right.
talking about our
Right.
policy.
Mhm.
We would just iterate, here are all the violations. That would be the
And
charges.
you can recommend punishment, you can't feel out punishment like a court of law could. So like you don't have that authority.
and if something is totally egregious, we can refer it to law enforcement. I mean, we,
Well, there is, yes.
And we have to in some
Yes.
cases,
Which
like,
you
yeah,
can-
yeah.
so,
But I'm assuming the charges are different than a recommendation for punishment.
Charges are not the punishment. It's
And
this is what you have
And
essentially been accused
Yeah.
of.
Yeah.
No, that we
Yeah.
found that we think you did do.
We did do, but don't you then go to a hearing
Yeah,
Right,
if you
have
are?
a chance
Jamie has an
to, you have a chance to argue your case against the charges. So it's a we believe based on the investigative report or the investigation we performed that you violated the policy. Now we're setting it for a hearing, so you have a chance to speak out against those charges. So it's giving people the opportunity for process.
There's
Okay.
you have to be careful. And we went through this, the reason is, and I think the House blends it even more, you have to be careful as you work through the process. Who's the charging agency? Who's the ones that are the judge? Where's the appeal go? And so, yours kind of works up. I think the House actually appealed to the same panel, the way I understood the rule, which is a little different. Yours actually would probably go to the rules committee if there was an appeal, but you still have to do your recommendation, so they get there anyway. So you have to be careful that this is not done as if you're the state's attorney. So, because otherwise you're giving the charges and kind of saying, we believe you did this. And then you call you an independent impartial hearing officer. So in essence, from our perspective, it would, if we were ever asked to draft some of this stuff up, it would really be done with what are the 2 statements, if one was assumed, it creates an issue as to how much of an investigation you do before you could do a little bit later. And that's one of the reasons that investigation's a little bit vague, your first investigation, because you may have to have it tailored to what the circumstances are. Sorry.
no, we saw it, this is why we're here. The hearings is quite, the next piece is.
Yeah, we don't want to start at this
I
point.
think you probably don't want to start it. We could jump and do the confidentiality piece and then come back next week to the hearings.
So there are really 2 things at the very end. One's confidentiality and maintenance of records. All the records dealing with this are considered confidential. It's put into your policy, it's adopted. And so in that sense, they're not subject to the Public Records Act. I think Legislative Counsel or Legal Counsel has recommended that that be included, so there's never a question. But generally, it would take at least, we keep them in a locked cabinet. It would take a court order before I produce any of them. I mean, that's, unless the Senate voted to, if we get requested, everything the Senate's gonna know requested. And so, you could decide to do otherwise, but without a court order, we would not be producing any of them. So that's the confidential. Generally speaking, remember the senators are usually, you can bind them to confidentiality. You cannot bind a complaint at any place.
We have found this to be the case.
Yes, okay, I'm just, sorry. But that is important to realize, your policy sort of tells the senator that it needs to be quiet. Because and the idea there is you're trying to respect the complaint. But the complaint at any time can go public, can say, I'm not gonna go part of this procedure, can go bring a civil suit if they wanted to. This policy is an attempt to work through the process in here. The only punishment really is what can be occurred within this building, and it has to be meted out by the Senate as a whole or by the committees on, the committee on committees. So this is not the full-blown alternatives for whoever may be the complaint. And at any time, they can withdraw from the process and just say, I'm calling up the press. And which also for those, remember, we are exchanging, a complaint comes in and a response comes in. Your rule says the complainant gets the response. There's nothing that keeps the complainant from saying, I'm going to go to the press with the response.
So they could do the whole.
Now, once it's open and it's public, the senator probably has an ability to respond, but the senator is really sort of under here. There's the expectation that the senator is not going public.
So I have a question on the maintenance of records, which is, we've just talked about your lock and key and how you'd have to have a court order to do it. It doesn't say, it says the Office of Ledge Counsel.
So that's,
Could we add?
That's for the House panel.
Okay,
the
so
Senate
we would
panel,
add
the Senate
Secretary of Senate instead.
No, that's just the next part of the sentence.
so
It's down to.
here's what happens.
Okay.
Once more, this is back to the Senate person's question. This was a joint one. This was kind of
Right,
together.
got it.
So generally speaking, any Senate records and anything you do, we keep.
Oh, yeah.
Anything that the
I
House
see.
does, Ledge Council keeps. There are potentially joint panels. And if it's a joint panel, it depends a little bit on who chairs it, because then it's kept either by IROC. That may want to be clarified, and at some point you'll want to address when you use these joint panels and when you don't, as I mentioned a couple weeks ago. But that was that language we did not change, but it really has to do with who keeps them depending on which chamber. I think it's fair, isn't it?
I think, given that, yeah, Damien, sorry.
And then, sorry, no, I just want to make sure that's my recollection. I think the joint, if there's still ever used a joint panel, I think it goes where the chair, if there's a panel, it's a joint panel, the chair of the Senate's on it, the chair of the House is on it. I think they each appoint 2 additional members. And then it depends really on sort of where those records are kept, depending on who's staffing it. And who's
So
involved.
where is a joint panel in this procedure?
So that is the policy itself that you adopted. I think I mentioned to you, I didn't know if they were necessary, would you want to visit in the
About
future?
doing the,
Yeah,
yeah,
the joint panel if it's Ledge Council, there's a joint panel if it's joint fiscal, it's on page 8.
oh
The
gosh.
Sergeant at Arms.
So that's at the end of the
Yes, and as I
right.
mentioned, I think before,
Well, actually, it's in the addendum, it's not in the.
as I mentioned, I actually believe that should be rewritten. Someone should talk to the House panel, because I think now that there's a human resources person, most everything would go through there first before it came to a joint panel. And at some point, I know we now have similar policies, but we probably are going to want to tinker with that.
With the addendum.
Well, it's going to have to take a little more rewrite than just that, but I think that should be addressed, because I really don't think anything relatively modest and below will be coming to a joint panel, because there's a human resource person now, and I would believe that most of it would probably go through human resources until it was something that couldn't be resolved, and then it would bubble up. So that's not the way this is envisioned. This is envisioned that if I look at somebody cross-eyed and they think it's a sexual harassment, it would go to a joint panel, well, actually go to the Senate panel. But if it was Damien, it would go to a joint panel. That's not the way it would occur in reality.
Right.
And then the annual report,
Oh, then the annual report is the last piece, and that's due at the end of December every year.
yeah, so generally speaking,
It's filed with you.
there used to be one, we did change this. There used to be, the joint policy said that there was supposed to be a joint report. So 2 years ago, we did one. The House changed their policy and did their own. And so this year, we did our own and actually cited it where we're supposed to do a joint one, but they changed their policy. So here's ours. It's posted on your website. I believe I changed this so that just the panel, I think this one only talks about the Senate now. The earlier version
Yes.
talked about both, but that is, it is posted. There's a report every year, and it's posted on the webpage for the committee.
Right.
This year we did it in January, just.
It was, well, I drafted it in December, but it didn't actually get posted till January. But it was for last year.
So thank you. I'm sorry that, I mean, this is great because it's the first time we're digging this. So if it's okay with you, May I beg your indulgence and ask again that we meet again next week to try and finish up the procedures? I'd love
Friday
to
lunch club,
get this all set. What?
Friday lunch club.
Well, it is the Friday
Yeah.
lunch
We don't
club.
even get brought lunch.
Although we didn't bring lunch, we brought snacks,
Which
which
is what we could do.
No,
I know
brought
where
a
the-
very-
I know where the refrigerator is. I can bring your lunch.
thank you, John.
I know where lots of refrigerators are.